Welcome to Talk Trials. I'm your host, and today we are going to obsess over a question that sounds deceptively simple, but absolutely torments the legal system.
It really does.
In the world of law, and certainly in the movies about law, everyone focuses on the drama of who wins. You know, who gets the massive payout, who goes to prison.
Who walks away vindicated. That's the big moment.
That's the headline. It's the climax of the movie.
But in the real world, the war is often won or lost, long before anyone even thinks about making a closing argument. It happens down in the trenches of procedure.
Right.
And the most dangerous, slippery question isn't who wins, but who gets to decide the case in the first place.
It's the ultimate gatekeeper question, isn't it? Before you can even start arguing about right or wrong, you have to establish who has the authority to even listen to the argument.
Exactly.
And today we're talking about a doctrine that acts like a trapdoor in the courtroom floor. You walk in, you're ready to sue a massive corporation, you're primed for your day in court, and then whoosh!
We're gone.
You've been dropped into what we often call a regulatory black hole.
We are talking about the doctrine of primary jurisdiction. And I know, the name sounds incredibly dry.
Oh, it's terrible. Yeah.
It sounds like something you'd skim over in a civil procedure textbook while, trying to stay awake.
Yeah.
But when you actually dig into the sources, and we have a stack of case law, history, and modern litigation strategy right here, you realize this isn't just a rule.
No.
It is a tactical weapon.
It is the invisible hand that stops the gavel from falling.
Right.
So here's our mission for this deep dive. We are going to pull this doctrine apart. We're going to trace its origins way back to the Railroad Wars of 1907.
Mm-hmm.
We're going to analyze the famous Napalm case that defined the Cold War legal landscape. And we're going to see how this exact same legal maneuver is being used right now, today, in massive opioid class action lawsuits.
And crucially, we're going to finish with our 10th chair segment. That's where we'll assess whether this doctrine is actually a necessary tool for a functioning government, or if it's just become, a sophisticated way to delay justice until plaintiff runs out of money.
Exactly. But before we get to the analysis, let's set the stage. I want to give you a scenario. I want you to imagine you are a business owner. Let's go back in time, way back to 1907. You're shipping cotton.
Okay.
Or let's jump forward. Make it the 1950s, and you're the U.S. Army shipping napalm. Or bring it to right now, and you're a state attorney general suing a pharma giant over addiction risks.
3 very different eras. Cotton, napalm, and opioids. It's quite a list.
Right. But the dynamic is identical in every single one of these stories. The plaintiff runs into court, they slam their fists on the table, they say, "Judge, I've been wrong. This railroad ripped me off. This drug company lied to me."
They want a jury.
They want a verdict. They want justice. And they want it now.
And the defendant. Usually a massive conglomerate with an army of expensive lawyers. They don't panic. They don't scream back. They just calmly raise a hand and say, "Judge, with all due respect, you aren't smart enough to decide this."
That takes some serious nerve. Telling a federal judge they aren't smart enough to hear a case.
Well, they phrase it a bit more politely, of course.
Of course.
They say, "Judge, this issue is too technical. It requires special competence. It involves complex regulations. We need to pause this trial and send this question to the true experts, the FDA, the EPA, or in the old days, the ICC."
And the judge often agrees. The gavel goes down. The case freezes, sometimes for years.
That pause button is the doctrine of primary jurisdiction.
Now, let's be really clear about what this is and what it isn't. It is a common law doctrine. That means you won't find it written in a specific statute passed by Congress. You can't look up the Primary Jurisdiction Act of 1907.
Correct. It is judicially created. It's a mechanism that judges invented to solve a very specific problem. It suspends the judicial process, the lawsuit, and it kicks a specific thorny issue over to an administrative agency.
And this isn't just a procedural timeout. This is fundamentally about the allocation of power. It's a tug of war, really, between the judicial branch, the courts, and the administrative state, all those agencies.
That's the core tension. We have courts to resolve disputes between private parties, but we also have agencies to regulate entire industries. When those two lanes merge, or worse, when they crash into each other, who has the right of way?
That's what primary jurisdiction decides.
Exactly.
So let's go back to the beginning, because this didn't just pop out of thin air. It started with trains, cotton, and a massive amount of confusion.
To really understand this, you have to transport yourself back to the turn of the 20th century. The Industrial Revolution is roaring, and the railroads, they are the absolute kings of the economy. They are everything.
Think of them like Amazon, the internet, and the interstate highway system all rolled into one giant, unregulated monopoly. If you were a farmer or a manufacturer or an oil driller.
You had zero choice. There was no alternative. You had to use the railroad.
And what happens with monopolies?
Exactly. Because they had a monopoly, they could do whatever they wanted. They were charging discriminatory rates, giving sweet deals to their friends like Standard Oil, and then gouging their enemies, their competitors. They could hold entire towns hostage to their pricing scheme.
There is chaos.
Complete chaos. So the government finally steps in. Congress passes the Interstate Commerce Act and creates the ICC, the Interstate Commerce Commission.
The first real federal regulatory agency.
That's right. And the goal was simple, at least on paper. Make sure rates are reasonable and fair for everyone. No more secret deals. No more backroom handshakes.
Okay, so now you have a regulator. The ICC is the new sheriff in town, but, and this is the key to the whole doctrine, you still have the courts.
Right. The statute that created the ICC didn't say you can never sue a railroad in court again. In fact, it explicitly preserved the common law right to sue for damages.
Which sets up a massive collision course. You have a new agency that says we regulate rates, and you have old courts that have always said we fix problems when people get ripped off.
And that collision happened spectacularly in 1907 in a case called Texas and Pacific Railway Co. Abilene Cotton Oil Co.
The Abilene Cotton case. This is the big bang of primary jurisdiction. If you're a law student, this is the case you highlight in 3 different colors.
It is the foundational text.
So walk us through the facts. It seems like a pretty standard dispute on the surface.
Well, the setup is incredibly simple. The Abilene Cotton Oil Company is in Texas. They need to ship cottonseed on the railroad. They get a bill from the railroad, and they think the rate is insane. It's unreasonable. It's pure price gouging.
So what do? They do what any American does. They sue. They file a lawsuit in a state court in Texas, and they're seeking reparations. They say, you overcharged us. Give us our money back.
And this wasn't an unusual thing to do. This is what courts were for. So the state court in Texas looks at the evidence. They look at the value of the service. They look at the rate, and they say, you know what? You're right. That rate was unreasonable. Railroad, pay them back. The jury agreed.
Victory for the little guy. The system works. Or so it seems.
But the railroad appeals. Of course they do. And it goes all the way up to the U.S. Supreme Court.
Yep.
And the Supreme Court, led by Chief Justice White, looks at this apparent victory for the little guy and sees a looming disaster.
Why? I mean, how does one oil company in Texas getting a refund threaten to break the entire economy?
Think about the implications, not just for this one case, but for the whole system. You have a railroad that crosses multiple state lines. Today, a district court judge or a jury in Texas decides that, say, 50 cents per ton is a reasonable rate. Great.
Okay.
But tomorrow, a jury in Louisiana looks at the exact same train, same cotton, same distance, and decides that 50 cents is unreasonable, and it should actually be 40 cents.
And then a judge in New York, maybe considering the railroad's higher costs up there, looks at it and thinks the reasonable rate should be 60 cents.
Exactly. You would have a patchwork of legal rulings. The railroad would never know what the legal rate actually was. It would change every single time they crossed a county line or a state border. It would be impossible to run a national business.
It would completely destroy the concept of uniformity.
That is the word, uniformity. The whole point of the Interstate Commerce Act was to stop discrimination, to make sure everyone paid the same published rate for the same service. If every local court could set its own reasonable rate, you're right back to chaos. You've completely undone the purpose of the federal regulation.
So the Supreme Court did something really bold here, even though the law itself said people could sue in court for damages.
They essentially said, no, not for this. In this specific situation, you can't.
So what did they rule?
They ruled against the Abilene Cotton Oil Company. They reversed the lower court's decision. And in doing so, they established the concept of what was then called exclusive jurisdiction. They said that whenever a case attacks the reasonableness of a filed rate, the court cannot hear it until the ICC has first decided what is reasonable.
They basically said, if we let a jury of 12 Texans decide this, we break the national system, so the agency has to go first.
That was the birth of the first great pillar of this doctrine. Uniformity. If we want a national standard, whether it's for shipping rates or pollution limits or drug labeling, we can't have 500 different judges making up 500 different standards on the fly.
The agency provides the one true north.
That was the idea.
Okay, so in 1907, this was a hard rule. It was a jurisdictional bar. You literally got kicked out of court because the court had no power to hear you. But over the last century, I mean, the administrative state has exploded. We have the FDA, EPA, XEC, SEC, OSHA. The list is endless.
It's an alphabet soup of agencies. And the doctrine had to evolve with it. It shifted from that strict, almost brutal, exclusive jurisdiction where the court is powerless to what we now call a prudential doctrine.
Prudential. That's one of those classic lawyer words that sounds very important. What does it actually mean in practice?
It means it's based on prudence, on wisdom, on good case management. The court has the power to hear the case. They aren't legally barred from it like in Abilene, but they choose to abstain. They hit the pause button to coordinate with the agency because it just makes sense to do so.
It's a choice, not a command.
It's a choice. It's a question of judicial discretion and timing, not of raw power.
I want to drill down on the mechanics of this because I think people visualize this wrong. When we say the judge refers the case to the agency, what does that actually look like? Does the judge, put the case file in a manila envelope and mail it to the head of the FDA?
No, and that is a huge misconception. It's not like a referral to a specialist doctor where your file just gets sent over and you show up for appointment. As the Supreme Court clarified in a later case called Ryder v. Cooper, the court doesn't really talk to the agency directly in that way.
So how does the agency even know there's a problem it needs to solve?
The judge enters an order that stays the proceedings. That means the lawsuit is frozen in time, no depositions, no discovery, no trial dates. It's just dead in the water.
On hold.
Completely on hold. Then the judge orders the parties, usually the defendant who asked for this in the first place, to go and file a formal administrative complaint with the relevant agency.
So the lawsuit is on pause, gathering dust in the court's basement. And meanwhile, the lawyers have to go start a whole new legal process over at the agency headquarters.
That's it exactly. They have to pay new filing fees, write new briefs, and jump through all of the agency's specific bureaucratic hoops. And the court just waits. It retains jurisdiction, meaning it doesn't dismiss the case entirely. And that's mostly to protect the plaintiff.
Right, because of the statute of limitations. That's a huge deal. If the judge just dismissed the case and the agency took, say, 5 years to decide the issue,
the plaintiff might be time barred from ever coming back to court. Their claim would have expired. So by staying the case, the judge basically keeps it in a coma.
A coma is a perfect way to describe it. It's not dead, but it's not going anywhere.
And once the agency finally rules, maybe years later, the parties take that ruling, run back to the courthouse, wake the judge up and say, okay, here's what the expert said.
And then the case resumes, but now the court uses that agency ruling as a key piece of evidence or maybe even as a binding fact. The agency says this rate is reasonable, so now, juror, your job is to decide the other issues, but you have to accept that one fact.
Precisely. The agency sets the technical parameter, and the court then applies the broader law within that parameter.
But here's the million-dollar question. When does a judge decide to do this? Is there a checklist, a flowchart they can follow?
This is the frustrating part for lawyers. The Supreme Court has explicitly said there is no fixed formula.
Of course they did.
It is incredibly unhelpful for lawyers trying to predict what a judge will do.
It's classic Supreme Court. We can't define it, but we know it when we see it.
Exactly. But looking at the body of case law, there are two dominant pillars that drive the decision. We already talked about the first one that came out of Abilene, uniformity. Avoiding that patchwork of conflicting rulings on a national regulation.
Okay, that makes sense. But the second pillar is the one that comes up most often today.
Yes. Expertise.
This is the stay in your lane argument.
Absolutely. It's the humble recognition that federal judges are generalists. They are brilliant legal minds. They can deconstruct the Constitution. They can interpret incredibly complex contracts.
Right.
But they are not chemists. They are not railway engineers. They don't know the physics of nuclear power plants.
So if the core of the case turns on a question of law, did this contract get breached? The judge says, I got this. But if the question is this specific chemical compound effectively a bomb? The judge says,
I'm going to ask the guys who regulate bombs.
And that is the perfect transition to the next case in our stack, because that is literally the fact battle.
It really is.
The Napalm case. United States v. Western Pacific Railroad Company from 1956. I love this case because on the surface, it's so boring. It's just a billing dispute. But underneath, it's about deep physics and safety engineering and the definition of a weapon.
It is the definitive case for the expertise pillar. So here's the setup. It's the Cold War era. The U.S. Army is shipping massive quantities of napalm across the country by train.
Napalm, for those who don't know, is this jellied gasoline mixture used in flamethrowers and incendiary bombs. It's nasty stuff.
It's very nasty stuff. The Army is putting this napalm mixture into big steel drums and loading them onto railroad cars. Now, the railroad has a price list. It's called a tariff. It's a public document. And they have two different categories that might apply here.
Okay.
One category is for incendiary bombs.
Yeah.
That's expensive to ship because, well, bombs are dangerous. They require special handling.
Makes sense. And the other rate?
The other rate is for gasoline and steel drums, which is much, much cheaper.
So the railroad looks at these drums and sees dollar signs. They point to the tariff line for incendiary bombs and say, that's what you owe us, the high rate.
And the Army pushes back. They say, whoa, hold on. These aren't bombs. They're just drums of jelly. They don't have fuses. They don't have bursters or detonators. They can't explode on their own. We are paying the gasoline rate.
A huge price difference, I imagine.
Massive. So the railroad sues the government in the court of claims to get the higher rate. Now, put yourself in the shoes of the trial judge. You have a document, the tariff. It has words in it. Incendiary bomb. Judges read words for a living. Why can't the judge just open a dictionary, look up bomb, and decide if a fuseless drum of napalm counts?
That seems like exactly what judges do every day. Statutory interpretation. Textualism. What is the plain meaning of the word?
That's what the lower court thought. They said, this is a question of law. We can read. We don't need the ICC to tell us what a bomb is. But the Supreme Court disagreed. They said, no, you can't. They invoked primary jurisdiction and sent the issue to the ICC.
Why? I'm still stuck on this. What makes the word bomb so special that a judge can't read it?
Because in the context of a railroad tariff, incendiary bomb isn't just a word. It's a term of art that's based on cost allocation.
Okay, unpack that for me. Cost allocation.
The court said that the reason you charge more for a bomb isn't just because of its dictionary definition. It's because of the safety risks and the handling costs associated with it.
Ah, I see. It's about the economics of danger.
Exactly. To know if a drum of napalm should be charged as a bomb, you need to know. Is it as dangerous to transport as a fully assembled bomb? Does it require the same level of insurance, the same careful handling procedures by the railroad staff? Does it cost the railroad the same amount of money to move it safely?
And who knows the answers to those questions? Not the judge. The judge has no idea what the safety protocols for shipping napalm are versus regular gasoline.
But the Interstate Commerce Commission does, or at least they're supposed to. They're the ones who approve the rates in the first place, presumably based on those safety and cost factors. So the court sent it to the ICC. They basically said, we don't need a linguist. We need a safety engineer and an economist.
This really solidified the idea that even if a question looks like a simple legal interpretation on the surface, if the words themselves are technical terms that require administrative expertise to understand their context,
the agency gets the first look.
But, and this is crucial, there has to be a limit. It's not like every time a big word appears in a case, the judge has to throw up their hands and give up. The courts are very protective of their own power.
Oh, absolutely. And we have to talk about the counterexample in the sources, the case that draws the line. It's Great Northern Railway Company v. Merchants Elevator Cum from 1922.
So this came before the napalm case?
Yes, decades before. But it sets the boundary. It was another dispute over a railroad tariff. But here, the dispute was purely about syntax, the grammar of a sentence in the tariff document.
So there was no debate about chemical composition or safety costs or anything technical?
None whatsoever. It was just, does this clause in this sentence apply to this particular railroad station? It was a reading comprehension test, pure statutory construction.
And in that case, the Supreme Court said?
They said, Judge, do your job. They denied primary jurisdiction. They ruled that, and this is the key quote, what construction shall be given to a railroad tariff presents ordinarily a question of law.
So the lesson is, if it's just reading a contract or a statute, the court keeps it. If it requires understanding the underlying physics or economics that gave rise to the words in that contract,
the agency gets it. That's the dividing line between a question of law and a question of fact, or maybe more accurately, a question of law and a question of policy.
Okay, so we have the two main pillars. Uniformity, which came out of Abilene, and expertise from Western Pacific. But there is a third scenario that is a bit weirder, a little more complex. What happens when the lawsuit is about something the agency doesn't handle at all, like antitrust law?
This brings us to the Ricci v. Chicago Mercantile Exchange case from 1973. This one is fascinating because it's not really about rates or technical terms. It's about immunity.
All right, so walk us through it. Ricci is a member of the Chicago Mercantile Exchange. He's a trader. And he gets kicked out. He loses his seat on the exchange.
Which is his entire livelihood.
Right. So he sues, claiming the exchange conspired with others to destroy his business, which, if true, would be a clear violation of the Sherman Antitrust Act.
Now, the exchange has a defense. They say, we weren't conspiring against him. We were just enforcing our own internal rules. We have a rule book. It was approved by the Commodity Exchange Commission, and we simply followed it.
And here is the conflict. If the exchange was genuinely just following valid, federally approved rules, they'd generally get immunity from antitrust laws. You can't be sued for doing what the government told you that you could do.
Right. But if they weren't following the rules, if they just used the rules as a pretext, as a cover to kick Ricci out for personal or anti-competitive reasons, then they absolutely can be sued under antitrust law.
So the judge in the antitrust case is in a tough spot. To decide the ultimate antitrust question, he first needs to know a preliminary fact. Did the exchange actually follow his own rules?
And who is the expert on the rules of the Chicago Mercantile Exchange?
The Commodity Exchange Commission, the agency that oversees it.
Bingo. So the Supreme Court sent that specific factual question to the commission first. Not because the commission knows anything about antitrust law. They don't. That's the court's job. But because the commission was the only one who could authoritatively answer the factual question, did they follow the rules or not?
So the phrase the court used was materially aid.
Yes. The agency's decision on the rules would materially aid the court's later litigation on the antitrust claim. It acts as a stepping stone. The agency solves the specific technical mystery and then hands the baton back to the court to finish the race.
So primary jurisdiction is essentially a sequencing tool. It's about the proper order of operations. Who needs to speak first to make the whole process work correctly?
Exactly. But as we move into the modern era, this sequencing has become a massive battleground. Because, let's be honest, going to an agency isn't like going to the drive-thru.
No.
It takes forever.
And this brings us right to the current controversies. Because lawyers are smart. They realize that if they can convince a judge to use this doctrine, they can effectively put a lawsuit in a freezer for 3, 4, 5 years.
It's the delay defense. And right now, there's a massive split in the federal courts on how to handle this very issue. It's what lawyers call the circuit split on the standard of review.
Okay, we need to break this down because standard of review sounds super technical and boring, but it decides cases. This is basically asking, if a trial judge decides not to send a case to an agency, if they decide to keep the case, and the losing side appeals that decision, how much deference does the appeals court give to that trial judge?
Let's use an analogy. Think of it like a football game. The trial judge is the referee on the field. They make the call in real time. The appeals court is the replay booth upstairs.
Okay, I'm with you.
In some parts of the country, specifically the 2nd, 8th, and 9th circuits, which covers huge areas like New York and California, they use what's called de novo review.
De novo, from the Latin, from the new.
It means the replay booth doesn't care what the referee on the field saw. They watch the tape and they make their own call from scratch, as if for the first time. They view primary jurisdiction as a pure question of power. Either the court has jurisdiction or it doesn't. It's a yes-no legal question, and appellate courts decide legal questions without any deference.
So if a judge in California says, I'm keeping this case, I want to hear the witnesses, we're going to trial, the 9th Circuit Court of Appeals can swoop in and say, nope, you're wrong, send it to the FDA. And they don't have to prove the judge was crazy or biased, they just have to disagree on the law.
Exactly. It makes it much easier to overturn the trial judge's decision. But then you look at the other side of the country. The 1st, 4th, 5th, 10th, and DC circuits. They view this very differently. They see primary jurisdiction as a management tool.
They use the abuse of discretion standard.
Right. And using our football analogy, this is like the replay booth saying, well, the call in the field was close, the ref was right there, they saw the play unfold. Unless they were totally blind or obviously messed up the rule, we're going to let the call in the field stand.
They trust the trial judge because the trial judge is the one in the trenches. They're the ones who can look the parties in the eye. They know if the plaintiff is a small business on the verge of bankruptcy. They know if the defendant is just stalling for time.
We saw this articulated really well in the Southern Utah Wilderness Alliance case in the 10th Circuit. The court explicitly said that because primary jurisdiction requires balancing efficiency against the harm of delay, the trial judge is the best person to do that weighing.
So if you are a plaintiff, you'd much rather be in an abuse of discretion circuit. You want that trial judge to have the final say and the power to tell a big corporation, no, we are not waiting 5 years for the agency.
And nowhere was this more critical, more life or death than in the recent opioid litigation.
This is the tortoise and the hare problem.
It really is. You have these massive lawsuits, states, counties, families suing pharmaceutical manufacturers for allegedly minimizing addiction risks and using false advertising. People are dying now. The litigation needs to move now. That's the hare.
But the manufacturers, the defense, played the primary jurisdiction card brilliantly from a tactical perspective. They went to the judges and said, "Judge, you can't decide if we misled people about addiction risks yet. The FDA is currently conducting long-term studies on the efficacy of opioids. We need to wait for the tortoise to finish its scientific work."
They wanted to pause the trials until the science was perfect.
Which sounds so reasonable on the surface. Let's get the science right before we rush to judgment. But there is a huge trap here.
The trap is the burden of proof. The FDA operates on a standard of scientific certainty. They need randomized controlled trials. They need 95% confidence intervals. They need to be absolutely sure before they approve a drug or change a label.
But a civil court, a courtroom is totally different. A civil court operates on a preponderance of the evidence. Is it more likely than not, just 51%, that you misled people and caused harm?
So by forcing the court to wait for the FDA, the defendants were effectively trying to raise the plaintiff's bar for proof. They were trying to force the plaintiffs to have FDA-level scientific certainty proof just to win a civil lawsuit.
It's a clever way to change the rules of the game mid-play.
Exactly. And the results in the courts were completely mixed, depending on the judge and the circuit. We saw a court in California actually stay a case for 4 years waiting for the FDA to finish these studies. 4 years of silence while the opioid crisis raged.
But other courts in places like Oklahoma and New York said no. They refused the stay. They said, look, the FDA regulates drug safety and labeling, but it doesn't regulate state false advertising laws. We can decide if you lied to doctors in our state without waiting for a new 5-year federal study.
It really shows that judges are getting wise to this tactic. They're starting to realize that a legitimate call for expertise can easily become an excuse for indefinite delay.
And that's led to a modern workaround, right? A sort of a lighter version, a way to get the expertise without the years-long wait.
Yes. The amicus brief, the friend of the court brief.
I love this. It's so practical. Instead of the formal, heavy machinery of primary jurisdiction, where you pause the entire case and force the parties to file new administrative complaints,
the judge just sends a letter to the agency. Or has their clerk call, "Hey FDA, hey EPA, we have this tricky technical issue in a case before us. We're not sending it to you, but would you mind writing us a memo telling us what you think?"
It's so much more casual.
It's faster.
Yeah.
It's cheaper. The agency files a brief explaining its position. The judge reads it. The parties get to respond to it, and the case keeps moving forward.
Yeah.
It gives the court the benefit of the agency's expertise without the absolute nightmare of the regulatory black hole.
It seems like the system correcting itself. The old doctrine was too slow and cumbersome for the modern world, so judges and agencies informally invented a faster, more efficient path.
Precisely. It's judicial adaptation in real time, a very pragmatic solution to a very serious problem.
All right, we've covered the history, the mechanics, the napalm, and the opioids. I think it's time for us to step back from the play-by-play. It's time for us to take a seat in the 10th chair.
Let's do it.
For new listeners, the 10th chair is where we stop just reporting the sources and start assessing them. If we were the deciding vote on a panel of 9 judges sitting in that imaginary 10th chair, how would we rule on the future of the doctrine of primary jurisdiction? Is it healthy or is it broken?
We've looked at the good, the bad, and the very ugly, and our verdict is this. The doctrine is fundamentally sound in theory. We absolutely need it. But in practice, it's often broken. It is far too often weaponized to bleed out valid litigation through strategic, crippling delay.
Let's break that down. First, we have to defend the core theory. We have to talk about judicial competence versus judicial hubris.
We have to agree with the core rationale in Western Pacific, the Napalm case. We simply cannot have generalist judges deciding the flashpoint of napalm or the chemical efficacy of a new cancer drug de novo from scratch. There is a real danger in judicial hubris, judges thinking they are smarter than they are on every technical subject.
If a judge misinterprets a tariff based on safety engineering, they could accidentally force a railroad to ship hazardous materials in cardboard boxes. The public safety consequences of getting the technical facts wrong are just too high. We need the expertise pillar as a safety valve.
Agreed. A judge who thinks he knows more about train safety than the Federal Railroad Administration is a dangerous judge. So the expertise prong must stay. However, Where the doctrine fails, and this is where we would tighten the screws significantly, is what we've been calling the regulatory black hole problem.
The doctrine, as it's currently applied sometimes, operates on a fantasy. It assumes that if you refer a case to an agency, the agency will enthusiastically investigate the problem and give you a clear, prompt answer.
Which is, frankly, a fantasy. In reality, agencies are underfunded, they're overworked, and they are often politically paralyzed. They frequently ignore referrals from courts, or they take 5, 6, 7 years to issue a non-answer like, "We have no opinion on this private dispute."
We saw this in the opioid cases. If a court pauses a case to wait for an agency that has no real intention or mechanism to answer the specific question quickly, that isn't coordination. That is a denial of justice. Full stop.
Therefore, our 10th chair ruling is this. Courts must rigorously apply an adequacy of administrative remedy test. Before pausing a single day of litigation, a judge must ask tough questions. Does the agency actually have a process to answer this question, and will they do it in a reasonable time frame? If the answer is no, the court must keep the case.
No more open-ended stays. Put a clock on it. Tell the parties you have 6 months to get an answer from the agency. If you don't have one by then, this trial resumes.
Exactly. Force the issue. And that leads directly to our stance on the circuits, but we are firmly on the side of the abuse of discretion standard.
The 1st, 4th, 5th, and 10th circuits have it right. The de novo circuits, New York and California, are treating this problem too abstractly, like it's a law school exam question.
Primary jurisdiction has evolved. It's not a hard jurisdictional rule anymore. It's about case management. It's about a trial judge weighing the burden of a 3-year delay on a sick plaintiff against the potential benefit of some technical insight from an agency. The only person who can properly weigh that is the trial judge who is looking the plaintiff in the eye.
An appellate court in a distant city looking at a cold paper record shouldn't be second-guessing that very human, very practical management decision unless something went horribly, horribly wrong.
They should back off, treat it like other abstention doctrines. And finally, we have to highlight the most subtle, but maybe the most pernicious danger here. The danger of scientific uncertainty.
This is the most dangerous modern trend in how this doctrine is used. We cannot allow primary jurisdiction to be used as a backdoor method to impose the standard of scientific certainty on civil torts.
This goes right back to the difference between the FDA's mission and the courtroom's mission.
Two completely different things.
The FDA needs to be 99.9% sure a drug is safe and effective. That's their job. We want them to be that careful. But the courtroom is a place for resolving disputes based on the best available evidence, under a more likely than not standard. If a chemical company spills sludge in your backyard, you shouldn't have to wait 20 years for a perfect, peer-reviewed epidemiological study to sue them.
You should be able to use the evidence you have now to make your case to a jury.
Courts must be vigilant to ensure this doctrine isn't used to covertly change the burden of proof on the plaintiff. If we wait for perfect science in the courtroom, no plaintiff will ever win against a scientifically complex industry. Justice delayed for the sake of scientific perfection is justice denied.
That's the bottom line. It's a tool for coordination, not a tool for obstruction.
Well said.
So let's recap the journey we've been on. We started with the chaos of railroad rates in 1907, where the Supreme Court realized that without uniformity, the national economy would completely fracture.
We moved to the Cold War and the Napalm case, which taught us that expertise matters, that sometimes you actually need to know the physics of a bomb just to read a contract correctly.
And we landed in the modern era where this doctrine is the front line in the battle between the demand for scientific certainty and the right to speedy justice, especially in the opioid crisis.
Primary jurisdiction is that invisible hand in the courtroom. It's the gatekeeper. It decides whether your case gets a trial this year or whether it gets sent to the waiting room of the administrative state, maybe forever.
It's a messy, complicated, and powerful doctrine. But the next time you hear about a major class action against a regulated industry, whether it's big tech, big pharma, or big energy, and the case seems to just stall out for years, don't just assume the lawyers are being lazy.
Look for the primary jurisdiction motion. Look for the pause button. That's probably where the real fight is happening.
And that is where we will leave it for this deep dive.
Here's a reminder for everyone. Our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice.
Thanks for listening to Talk Trials. We'll see you next time.